Shalom. So, this Supreme Court decision that came out of Yeshiva University versus YU Pride Alliance. Whoa! It is fire. It is absolute fire. Um, and so I had to do a possibly short. I'll see if anybody's interested. Look at it. Wow. Okay, so just to explain what happened, a group of Yeshiva University students decided they wanted a YU Pride Alliance, and they wanted to be treated like all other clubs on campus. And Yeshiva University went, hell no, we're not going to do this. And they were taken to court, and the court decided basically that Yeshiva University, because it's an educational institution, cannot claim religious freedom and was subjected to a law requiring that it not discriminate um, based on gender, I guess. Well, we'll read this because honestly, this is just and so Yeshiva asked was going to so in New York they have very weird names for their courts. The lowest court is called the Supreme Court. Uh, um, and their higher court is called the Appellate Division. I think that might be their highest court. They have weird names. Anyway, so what happened is YU asked for a stay pending appeal, and New York said no. And YU did this Hail Mary pass of asking the Supreme Court of the United States for a stay. And since they're in New York, that's under Justice Sotomayor. And frankly, I was like, I don't know if Justice Sotomayor is going to give you a stay. But she did, right? Which, so the way the court is supposed to function is just because you have a liberal justice looking at your stays doesn't mean that you're going to get a very different decision than you would if you submitted to a more conservative judge. So, I mean, really, it's the clerks who look at a lot of this stuff, and the clerks are supposed to be even more even-handed, and the way the process is, it's meant to assure that you don't get different justice based on which justice your appeal for stay goes, and that's part of the collegiality of the church, right? As a church of the Supreme Court, and so she grants the stay, and today, Wow, computer. Okay, if you know what, this is completely off the thing, and you're not paying attention, so go away. I'm not gonna discuss stuff that's completely off what we're discussing. Um, okay, so today, um, the the court issued a um, it it undid the stay that Justice Sotomayor had granted. And I am sure that the story you're going to hear from the New York Times and everybody else is going to frame this as some sort of loss for Yeshiva University, which is why I'm like, oh my god, look at this opinion. It is fire. It is absolutely fire. Um, so what actually happened is that five of the four justices decided to vacate the stay by Justice Sotomayor, giving without prejudice, meaning that Yeshiva University could ask for the stay. So, without prejudice means we're actually not deciding anything. We're just telling you, you know what, you can file this again, but right now might not be the best time for us to be dealing with this because there are and they give it's a very short thing and they give Yeshiva University a few things that they're like, you know, if you were to apply for the state courts of New York in these ways, which you apparently haven't, then maybe they'll give you a stay, and then we won't have to deal with it. And when you read the dissent on this decision to vacate the stay, oh my god, it's like basically what the Supreme Court is saying to New York is, okay, one of two things is going to happen. You guys are going to find a way of giving a stay to this, or we're going to do what the four other justices want to do, which is overturn your decision without even comment. Like, they're not even they're not even saying, you know what, we'll cut, you know, you can. They're saying these facts that have been presented to us, we're just gonna tell you you're wrong, and we're going to basically kick you like in the behind. So let's go ahead and read what this is saying, because honestly, I don't think I have ever seen such a clear. I don't think I have ever seen such a clear, like, oh, why don't I have this up? I should have this up so you guys could see what I'm talking about. Sorry about that, guys. Um, Here, let me make this bigger so that people can see. Well, is this okay? Okay. So this is the opinion. It's actually I put a link in the description, so you can see the actual opinion. Um, that's funny that. Oh, I guess Alito's dissent starts. Uh, yeah. Okay. So let's see what happened. Okay. So, um, what happened was Yeshiva University asked for a stay of judgment, a stay of an order, which just means when a court gives you an order, the only good excuse you have for not doing what they say is if you go to a higher court and that higher court grants a stay, which is they're saying, hold on, you don't have to do this because we're going to be looking at it. And so Justice Sotomayor granted the stay and referred the opinion to the court. The court decided in a 5-4 decision to vacate the stay without prejudice. Without prejudice means we're not actually making a judgment. You can go ahead. So usually when something is denied with prejudice, that means that you can't file the same thing over again. When it's meaning that whatever you were asking for is going to prejudice any other filing for the same thing, because we've taken a look at this and we've decided, no, this is not what we want. You're not making a good motion before the court, okay? And so they motioned for a stay to the court. Justice Sotomayor granted it and referred it to the full court, the 9 justices. The justices decided in a 5-4 decision to say, no, we're not going to grant your application for a stay. We will consider it again if you ask the New York courts to review this or interim relief, right? And they don't give it to you, come back and ask us for a stay. And basically, yeah, we're going to give it to you, right? We'll give you at least the stay. And then the four justices who were like, no, this is not what we want to do, which are the 4 more conservative justices. That's Alito, Thomas, Gorsuch, and Barrett, right? They're like, no, this is not what we want to do. New York is just plain wrong. And on the stay, we're pretty much going to tell New York you're just plain wrong. Okay? So, okay. So, this application for stay pending appeal of a permanent injunction entered by the New York trial court, presented to Justice Sotomayor and by her referred to the court, is denied without prejudice to applicants, again seeking relief from this court if, upon properly seeking expedited review and interim relief from the New York courts, applicants receive neither, right? So they're saying, you guys didn't ask for all of the things you could ask New York courts to do, so it's not really necessary for you to come and ask us, because you could just be asking New York. And of course, if there are other avenues, the Supreme Court is like, well, you shouldn't come to us unless you've done everything else first. The order heretofore entered by Justice Sotomayor is vacated, but they're saying, but if the New York courts were to not grant you that stay, then then you can come and ask us for a stay. And they're pretty much hinting, yeah, that's what we'll do. We'll give a stay. Okay? Applicants, Yeshiva University, and its president seek emergency relief from a non-final order of the New York trial court requiring the university to treat an LGBTQ student group similarly to other student groups in its student club recognition process. So they're saying, oh no, that that trial court order, it's not really final because you could still appeal, and so New York isn't really making you do it, even though Yeshiva University's been like, the New York courts have pretty much been like, no, you have to do this immediately, right? The application is denied because it appears the applicants have at least 2 further avenues for expedited or interim state court relief. Really, the lawyers for Yeshiva University didn't seem to think they did. But the Supreme Court's saying, yeah, you guys should ask New York again. First, applicants may ask the New York courts to expedite consideration of the merits of their appeal. Okay, so what happens is when you ask for a stay, right? When you appeal, you say, hey, courts, appellate courts, I want you to take a look at what this lower court decided, and in the meantime, don't make us do what the court said, right? So court tells them you have to recognize the Pride Club, and you have to do it now. And so when you appeal to a higher court, you say to the higher court, hey, this is my appeal, and at the same time, I would like you to say that I don't have to do the things that the court is telling me I have to do right now, right? And so what the Supreme Court is saying is, yeah, you filed an appeal and you asked for a stay. You asked them not to make you do it. But what you didn't ask is for them to immediately consider the merits of your appeal, the actual appeal, right? You asked them to hold off on the order, but you didn't ask them to, like, right now listen to the court, which is kind of like it's kind of like saying, I'm trying to think of an analogy, like imagine your mom tells you, hey, go clean your room, and you think you're gonna go to a higher authority, and you say, hey, Dad, I don't think I should be clean. Let's say your mom says I should says, hey, wash the dishes, right? And you're thinking, let me go to a higher court. Let's say, for instance, that your dad is a higher court, right? You go to Dad, and you're like, hey, Dad, Mom said I had to wash the dishes. I don't think I should have to wash the dishes. Could I not wash the dishes for like half an hour? And your dad's like, no, you need to go wash the dishes right now. And the Supreme Court's reaction is, but you didn't ask your dad to consider, you only asked your dad to consider if you don't have to wash the dishes right now. You didn't ask your dad to consider if you should ever wash the dishes, right? And it's like, are you joking? But that's what they're saying. Applicants do not assert, nor does the appellate division docket reveal, that they have ever requested such relief. So they never actually said hey, Dad, I should never have, like, I should never wash the dishes. And, and, and it's like, please. Okay. Second, applicants may file with the appellate division a corrected motion for permission to appeal the court's denial of a stay to the New York Court of Appeals. Okay, so in New York, you have the Supreme Courts, and then you have the appellate division, and then you have the New York Court of Appeals above that. Okay, so what they're saying is, you asked the appellate division a for for permission to the New York Court of Appeals, right? But there was a correction that the appellate division clerk's office asked you to do on August 25th, which you didn't do that, and you need to do that first. I'm not sure exactly what happened there, but like they found another like possible thing you could do that maybe then the New York courts would give you appeals, right? Applicants may also ask the appellate division to expedite consideration of that motion, right? So, basically, the Supreme, these are the liberal justices. The liberal justices are like, go back to the New York courts, ask them to put a stay on this, and if they don't, we'll do it. Wink, wink, nudge, nudge. New York courts, you need to grant this stay. That's basically what they're saying. If applicants seek and receive neither expedited review nor interim relief from the New York courts, they may return to this court, right? So, if they actually try this from the New York courts and they don't get it, then they can come and ask us. But right now, there's no reason to ask us because the New York courts can do it. I hope it's clear what's actually going on here. I'm gonna take a look at all of the comments. There's been a bunch of comments. Why is there a Supreme Court case between the universities? It's not a Supreme Court case between the universities. YU Pride Alliance is a club trying to be formed on Yeshiva University's campus, and Yeshiva University would not allow them to be a legitimate club on campus, so they filed in New York court asking the New York courts to current and former Yeshiva University students sued to force the school to recognize an LGBTQ club on campus. Like, does Yeshiva? Yes, of course, Yeshiva University. I am assuming they are Orthodox. Yes, they are. They're modern Orthodox, but they're Orthodox. I mean, I am against their ideas too, so I can see their point. I can see, yeah, I would not want to allow the club. So, well, that's what the New York Times is going to tell you, but it's not true. Goes against the Torah. Without prejudice is they can file again. Yes, they can. Yes, without detriment. Kind of. Yeah. Secular in New York. Okay. If the university wasn't in a red state, then the court would have support. Yeah, I mean that's what a lot of it. They can ban all clubs if they needed to. That's actually what they were considering. But yeah, This court decision. Wow, this court decision is absolutely fire. Um, they can isn't required to have clubs, right? That's a ban. Yeah, that's basically what a lot of people are saying. Should talk to the school first before me. Okay. It sounds like the gay club was not treated the same. That's what it's about. They were not a recognized club, but if the school doesn't want a gay club, they can ban all clubs. Yeah, basically. Um, okay. If the higher power goes against standards, then they have the right to be stopped. Not sure what you're saying. This is just woke stuff. It is. Clubs aren't required, but I feel it should be not be able to. Right. I agree with that. Uh, okay. The school is being accused of not treating the applicant the same for clubs. Um, yeah. Um, okay. Um, Yeah, but the Supreme Court is saying it doesn't matter, and that's what the dissent you'll see in the dissent. Um, okay, so this is the dissent, and it's just fire. It's just absolute fire. Um, Justice Alito, with whom Justice Thomas, Justice Gorsuch, and Justice Barrett join dissenting, and basically they're saying, no, 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 screw this. We have we. It's obvious what we should do here, and um, we should just tell New York, um, GTFO. Does the First Amendment permit a state to force a Jewish school to instruct its students in accordance with an interpretation of Torah that the school, after careful study, has concluded is incorrect? The answer to that question is surely no. The First Amendment guarantees the right to the free exercise of religion, and if that provision means anything, it prohibits a state from enforcing its own preferred interpretation of Holy Scripture. Yet that is exactly what New York has done in this case, and it is disappointing that a majority of this court refuses to provide relief. So what they're basically saying is this court should just tell New York, screw you. Yeshiva University hosts our nation's largest Jewish undergraduate institution. That program is structured to help students embrace the Jewish faith and engage with the secular world with a foundation of Torah values. Thus, Yeshiva expects its undergraduate students to live in accordance with halachic norms, that's Jewish law, and Torah ideals. A student group, the YU Pride Alliance, vehemently disagreed with Yeshiva's interpretation of Torah with respect to sexual relations between members of the same sex. So it applied for recognition as an official student group in order to, quote, make a statement and promote, quote, cultural changes in the institution. To facilitate those goals, the Alliance planned to host events that framed Jewish practices and religious events through an LGBTQ lens. Quote, after much deliberation and in consultation with senior rabbis, Yeshiva concluded that recognizing the alliance would have, quote, implications that are not consistent with Torah. Doing so, Yeshiva believed, would, quote, cloud the nuanced message of Torah, which, quote, accepts each individual with love, but also, quote, affirms its timeless prescriptions. The university, therefore, denied the Alliance's request for formal recognition, but made it clear that students could, quote, socialize in gatherings as they see fit. Dissatisfied with this response, the Alliance sued Yeshiva in state court, claiming that its refusal to recognize the group violated a provision of the New York City human rights law that prohibits discrimination on the basis of sexual orientation and gender. The trial court agreed. Perfunctorily, which is how courts say without actually paying attention, dismissing the university's First Amendment arguments, the court ordered Yeshiva to recognize the group and to, quote, immediately grant it, quote, the full and equal accommodations, advantages, facilities, and privileges afforded to all other student groups. The court denied Yeshiva's request for a stay pending appeal, and when the university applied to the appellate decision and the Court of Appeals for interim relief, these courts refused providing a single without providing a single word of explanation. As a last resort, Yeshiva turned to this court, but the majority, for no good reason, sends the university back to the state courts. The upshot is that Yeshiva is almost certain to be compelled for at least some period of time, and perhaps for a lengthy spell, to instruct its students in accordance with what it regards as an incorrect interpretation of Torah and Jewish law. An applicant may obtain a stay pending appeal if it makes a strong showing, one, that it would likely prevail if review is granted, that it will that it will suffer irreparable harm during the time it takes for the completion of the appellate process, and 3, that neither the interests of other parties nor those of the public militate in favor of denial. Yeshiva easily satisfies all these requirements. At least 4 of us are likely to vote to grant certiorari. So when the court grants certiorari, that means it takes up an appeal. If Yeshiva's First Amendment arguments are rejected on appeal, and Yeshiva would likely win if its case came before us. So they're basically signaling, we're going to rule in Yeshiva's favor if this comes to this court. A state's imposition of its own mandatory interpretation of Scripture is a shocking development that calls out for review. The Free Exercise Clause protects the ability of religious schools to educate in accordance with their faith, and it gives a bunch of things. Restrictions on religious exercise that are not neutral and of general applicability must survive strict scrutiny. So they're saying that their standard of review is going to be strict scrutiny. Church of Lukumi Baba Luaye Inc. is actually a really interesting opinion about religious freedom that a lot of people will find shocking. And the New York City human rights law treats a vast category of secular groups more favorably than religious schools like Yeshiva. The New York City human rights law exempts any corporation incorporated under the benevolent orders law or described in the benevolent orders law. It is therefore inapplicable to large groups like the American Legion and the Loyal Order of Moose, as well as smaller groups like the United Scottish Clans of New York and New Jersey, right? And basically under Church of Lukumi. And if you treat a church worse than any other organization, if anybody else is allowed to do something and a church is not, basically it's considered a void. But Yeshiva was denied an exemption, and there has been no showing that granting an exemption to Yeshiva would undermine the policy of the New York City human rights law to a greater extent than the exemption afforded to hundreds of diverse secular groups. Accordingly, strict scrutiny applies, meaning this isn't going to work. Based on the papers submitted to us in connection with this application, it is not likely that the Alliance could satisfy its burden under that standard. Unless a stay is granted, Yeshiva will be required to recognize the alliance as an official student group and to grant it all the privileges extended to other such groups. As the alliance has contended, this would force Yeshiva to make a statement in support of an interpretation of Torah with which the university disagrees. The loss of First Amendment rights for even a short period constitutes irreparable harm. Roman Catholic Diocese of Brooklyn versus Cuomo, 2020. I think this was about COVID. And the appellate process in the state courts could easily drag on for many months. And as for the interest of alliance members and the general public, while a stay would deprive the alliance of the statement it wishes to obtain, alliance members would not be prevented from socializing and conducting activities that do not require official recognition. The majority does not address our well-established standard for granting a stay, but instead suggests that we cannot grant a stay because the New York courts have not entered a final order. But the state court's denial of interim relief constitutes a final order under National Socialist Party of America versus Skokie, which is another interesting thing. It is ironic that the theory that supported a stay in that case is eschewed here. Moreover, it is far from clear that our authority to issue a stay of a state court order that violates the Constitution is limited to situations in which a final order has been entered below. So they're like, yeah, we can just, Okay. The majority instructs Yeshiva to pursue two avenues of relief in state court before filing another application here. First, the university is told to seek expedited consideration of the merits of its appeal, ante at one, but even expedited review could take months, and during all that time, the university would be required to continue to make the statement about Torah that it finds objectionable. Thus, an expedited appeal in and of itself would not be sufficient to protect Yeshiva's First Amendment rights. Correct, but what would happen is that if New York isn't absolutely idiotic, while they grant the expedited appeal, they would order a stay, which is what they should have done anyway. Second, and more to the point, the majority seems to think that it is still possible for the university to persuade the Court of Appeal to grant a stay. Of course, the Court of Appeals has already denied Yeshiva's application for interim relief, but the majority interprets a case comment written by a court clerk employed by the appellate division to mean that the Court of Appeals may give Yeshiva a second bite at the apple, notwithstanding its previous denial. Of course, they're just signaling to New York. They're like, that interpretation is dubious, yet the majority seizes upon it as dispositive. I doubt that Yeshiva's return to state court will be fruitful. Really, I'm guessing the New York courts are not going to be that stupid, and I see no reason why we should not grant a stay at this time. It is our duty to stand up for the Constitution, even when doing so is controversial. For these reasons, I respectfully dissent. If New York refuses to grant the stay that Yeshiva is now going to ask for, all that would be required is for Yeshiva to come back to the Supreme Court, and the only thing, Justice Alito's like, yeah, New York isn't going to actually grant the stay, and we'll see. Maybe it won't. That would honestly, I think, make the two conservative justices who voted along with the three. So who are the two Roberts and Kavanaugh are the ones who voted with Sotomayor and Kagan and Jackson now because Breyer's gone. Frankly, I would expect even Kagan to be upset at New York for not doing so. Maybe Jackson and Sotomayor. I mean, they are so ideologically possessed by the wokerati that they'll probably do it in any way. But yeah, California. I know a synagogue here that had. Yeah, that's reform. Reforms like that. I'd just shut all the clubs down until resolved if I ran that school. But that the Supreme Court's not like saying that. Isn't there a clear violation of freedom to assemble? I mean, that's not what they were trying to do. No one can compel me to associate with a gay school. Oh, you mean freedom to associate? I mean, yeah, but this goes so beyond this. Yeah. Okay. Unless anybody has questions, comments, anything else, I think that will do it for me for today. For this, I actually am planning on doing another one later. But this was really surprising. I Alito and the other conservative justices are saying, that's not what the real argument is about. I mean, that's not how the thing is. You guys are all going sideways from the actual opinion. The opinion is pretty clear. Um, um, yeah. Let me see if I can find. A uh, of course, this is such bullshit. I absolutely hate that the courts that the news says shit like this. Washington Post. Supreme Court says Yeshiva University must recognize LGBTQ clubs for now. Not really. Supreme Court declines to block order requiring Yeshiva University to recognize. Supreme Court rejects, right? Supreme Court sides with LGBT. Even the New York Post is doing it. Supreme Court says Yeshiva University must allow, and they're just lying. They're just lying. They have to know better than this. So let's look at their stupid article. Adam Liptak. The Supreme Court said on Wednesday, what are they saying? Where what are they? This is the actual Supreme Court thing. That it would let stand for now a ruling that Yeshiva University must recognize an LGBT student group. The vote was 5-4, with the majority saying that the university, a modern Orthodox Jewish institution in Manhattan, must first pursue challenges to the ruling in state court. Justice Samuel Alito, writing for the four dissenters, said that further challenges were pointless and that the majority had inflicted grave harm on the university's right to religious freedom. Again, they're framing this. A state's imposition of its own mandatory interpretation of Scripture is a shocking development that calls out for review, he wrote. The majority's order was brief, unsigned, and provisional, which is typical when the justices rule on applications seeking emergency relief. It criticizes the university's litigation strategy, saying its lawyers had not asked a state appeals court to speed its appeal and had not properly sought to block the trial judge's ruling in the meantime. Again, it's like, what bullshit. And of course, you should expect it from the thing. Whatever. If applicants seek and receive neither expedited review nor interim relief from the New York courts, they may return to this court, the order said. It reflected the votes of Chief Justice Roberts, Sotomayor, Kagan, Kavanaugh, and now Brown-Jackson. The order dissolved an interim stay entered last week by Justice Sotomayor. Justice Alito wrote that requiring the universities to seek relief in the state court amounted to ruling that it must, at least for a time, give up its religious rights. And this is actually the part I would disagree with Alito. I doubt that Yeshiva's return to state court will be fruitful, and I see no reason why we should not grant a stay at this time. If New York does actually, it would be so dumb. It is our duty to stand up for the Constitution, even when doing so is controversial, which is another stupid thing for him to... I'm sorry. He should not say this. This is not controversial. What's controversial is the opposite. Thomas, Gorsuch, and Barrett joined Alito's dissent. The case started when students at Yeshiva, which says it is the world's premier Torah-based institution of higher education, whatever. Justice Cutler of the State Supreme Court in Manhattan. New York has the dumbest names for its courts. The lowest court, the trial court, is called the Supreme Court in New York. Ruled for the students on a technical ground. The university, whatever. The university appealed, and a state appeals court is likely to hear arguments in the case in the coming months. The university also asked two appeals courts to stay Cutler's injunction while the appeal moved forward, a request the courts denied. In Wednesday's order, the majority said it appeared that the university had not followed the right procedure for seeking a stay from the state's highest court. The university, represented by Beckett Fund, sought emergency relief. Its application said the injunction violated its constitutional rights. Without an immediate stay of the permanent injunction, the nation's leading Jewish university, lawyers for the students responded that intervention from the Supreme Court was unnecessary and premature. Whatever. Only harms it. Whatever. Go away. A lawyer for the university, Eric Baxter, a lawyer, said the court's order was a temporary setback. Is it? Today, the Supreme Court instructed Yeshiva University to make an additional effort to get the New York courts to grant them emergency relief, and made clear that if that protection is not provided, they can return to the Supreme Court to seek its protection again. The court's order meant that the justices will not, for now, address the latest clash between anti-discrimination principles and claims of conscience. Masterpiece, whatever. But last year, okay, the bullshit article reframing this in ways it shouldn't. New York Post should have a better article, but I doubt it will. The Supreme Court refused to block a state court ordering whatever. The majority wrote that the Orthodox University first needed to pursue all options available in state court. Okay, the application is denied because it appears the appellants have two further avenues for expedited or interim state court relief. Yeshiva has brought the case. Whatever. The majority of justices on Wednesday said Yeshiva would first have to ask New York courts to expedite considering the appeal, which they say the university had not done before elevating the matter to SCOTUS. Yeshiva could also file for permission to appeal the stay to the highest state court, they wrote. Then they could go back to the Supreme Court. They added that Yeshiva will likely win if the case were to come again before the Supreme Court. Eric Baxter, representing the university, said the officials would follow the court's instruction. Yeah. I mean, it's a tiny bit better, but it also does not frame this properly. So, don't know what to tell you. Let's see how CNN puts this. The Supreme Court, in a 5-4 vote, declined on Wednesday a request to block a lower court. In an unsigned order, noted that the New York State Court had yet to issue a final order in the case, and that Yeshiva could return. So this is actually better than even the New York Post article. Dissented, noting that the lower courts could take months to rule. I see no reason why we should not grant a stay-in at this time. Noting that the school objected to recognizing a group. Justice Sotomayor, who has had temporarily blocked the order last week, the court's order is a rare loss for now for supporters of religious liberty. See, bullshit. Last term, Alito has repeatedly called for greater protection of religious. In ruling against Yeshiva, trial court focused on the qualified. The court noted, however, that this is a better article, honestly, than New York Times and New York Post. In court papers filed with the Supreme Court, not only do the applicants leapfrog... Okay, now this is, I guess, where... leapfrog the entire state appellate process, but they also press the court to address both novel and weighty First Amendment questions on a rocket docket without the benefit of full briefing or oral argument, lawyer Catherine Rosenfeld told the justices in court papers. Yeah, go away. Rosenfeld said the lower court ruling simply requires the university to grant the Pride Alliance access to the same facilities and benefits as its 87 other recognized student groups. This ruling does not touch the university's... okay, go away. Jillian Weinberg, a student at Yeshiva, told that Furkov recognized even if Yeshiva's undergraduate school does not. Well, that's sad. She said that Furkov's faculty and students are concerned with the harm that President Ari Berman's actions will cause to the mental health. You know what? Then the Graduate School of Psychology needs to change its things. Yeah, I mean, honestly, we'll see what happens. Okay, unless there are questions, I am going to end this broadcast and have another one sometime later. Bye, people.